Hello, I'm Judge Michael McShane, and I preside over the Early Resolution Program for first-time DUII offenders. In this brief video, I want to talk to you about who is eligible for the program, the purpose of the program, and what is expected of the probationers who participate in the program. You are eligible for this program if you are here on your first conviction for driving under the influence of intoxicants. Some of you may have been arrested for driving under the influence of intoxicants in the past and successfully completed a diversion program. You are still eligible for the Early Resolution Program. Some of you may have convictions for DUII in other states. If that is the case, you are not eligible for the Early Resolution Program. You may have other charges in addition to your charge of driving under the influence of intoxicants, such as reckless driving. These additional charges may or may not be dismissed if you enter this program. Please talk to your attorney about what will happen with these additional charges. The purpose of this program is to get people charged with their first DUII into probation quickly and to make sure that they succeed on probation. For most people, having this charge is stressful and causes you a lot of embarrassment. We understand that. I know that you are concerned about losing your license, you're concerned about the financial obligations involved with the conviction, and you're concerned about having to serve jail time. On average in Multnomah County, people who are convicted of their first charge of driving under the influence of intoxicants serve 5 days in jail, and the fines and fees total $1,500. Those are just the court fees. Those are in addition to fees that the program providers may charge. It's no wonder that many people want to put off resolving a charge of driving under the influence of intoxicants. The purpose of this program is if you enter the program, the costs and the jail time are deferred for 60 days in order for you to show me that you will take the probation seriously. If you can complete certain conditions in 60 days, primarily around getting yourself into treatment, you will not receive a jail sentence and your financial obligations will be significantly reduced. On the other hand, if you are not able to complete those conditions, you will begin a 30-day jail sentence and you will pay the full statutory fees. So here are the requirements of the probation if you choose to enter the program. First, you will be placed on what's called enhanced bench probation monitoring. It'll be a 2-year probation period. This is not a supervised probation in that you do not have a probation officer. Bench probation means that you're on probation to the court. So in other words, myself and my staff will supervise your probation. The monitoring system aspect of the probation means that you'll be placed in a computer data bank. If you have any police contact, the system notifies me of this contact. Primarily, this is to stop people from driving while suspended during the 1-year period of suspension. Your license will be suspended for 1 year. We'll talk more about that in just a moment. If you do get pulled over for driving while suspended, the system does notify me, and I do issue a warrant for your arrest. So let's talk about the driving piece. Department of Motor Vehicles will suspend your license for 1 year with this conviction. There's nothing I can do about that piece of it. That's the law. You may be eligible for a hardship or occupational license. If you get a hardship or occupational license, I will take you off the monitoring program and you will not have to pay those fees. You will remain on bench probation. Keep in mind that it is Department of Motor Vehicles who sets the rules as to whether you're eligible for a hardship or occupational license. They will give you some documents that they will want me to sign, and you can bring them those to me and I will sign them. Again, once you get some form of license, whether you get your license reinstated after a year or you get a hardship or occupational license, you no longer have to be in the monitoring system. So what are the other conditions of probation? First, you may not possess or consume alcohol. You must submit to field sobriety or breath tests if requested by the police. You may not enter any establishment whose primary income is derived from the sale of alcohol, so you may not go into a bar, liquor store, or tavern. If you work at such an establishment, please let me know, and we will talk about a work exemption. You must obtain a DUII evaluation and complete the recommended treatment. When you leave court, we'll tell you exactly where you need to go to have this evaluation done. The evaluation costs up to $150. You're to attend a one-time class called the Victims Panel. Again, we'll tell you when you leave court how to sign up for that class. There is a fee for that class. I believe the fee is currently $50. You're to complete 80 hours of alternative community service. This can be done through the court's community service office, or if you prefer, you can set your own schedule, your own hours, through a nonprofit or community-based organization of your choosing. Places that people go include places like the Oregon Food Bank, the Oregon Humane Society, the Rebuilding Center in North Portland, Old Folks Home, hospitals, schools, the Boys and Girls Club. Any of those kind of community-based programs would be the kind of places that would have you do volunteer work. You need to get 25 hours done in the first 60 days. So let's talk about the first 60 days of the probation. The purpose of this program, is to get the probation started quickly. In the first 60 days, 3 conditions have to be met. You have to complete the DUII evaluation. You have to complete that one-time class called the Victims Panel. And of the 80 hours of community service, 25 hours have to be completed in the first 60 days. You'll come back to court in 60 days, and when you leave court, if you choose to enter the program, you'll be given a court date where you'll come back to see me in 60 days. If those 3 things are completed, I'll suspend all of the jail time, and I will significantly reduce your financial obligations. And we'll have a discussion about what your financial situation is. If those things are not done, you do begin a 30-day jail sentence that day, and you do have to pay the full court financial obligations. We do want you to succeed. If you enter the program, our goal is to have you succeed, to get into treatment quickly, and not to come back to court on a second, third, or fourth DUII conviction. We do understand that emergencies occur. Family emergencies, health problems, problems at work. If something is preventing you from getting the things done in the first 60 days, preventing you from succeeding in the first 60 days, you need to call my staff immediately. If we do not answer the phone, leave a message. We will return your call. Or call your attorney and have your attorney call my staff. If there's a true emergency and you cannot get things done in the first 60 days, we will work with you, but we need to know about it. Do not wait until the hearing or until the last few days before the hearing to call my staff and tell us you have a problem getting everything done. Again, we will work with you if you have an emergency. We will give you extra time if you have an emergency, but you need to talk to us about that prior to the hearing. Most people who come back to court in the 60 days complete everything that's required of them. Only about 1 in 20 fails to complete the 3 things. And again, I know I repeat these, but they are the Victims Panel, the evaluation, and 25 hours of community service. The people who fail most often fail because of addiction issues. If you have an addiction issue that's getting in the way of you succeeding, you do need to come by, talk to me and my staff about that issue. If the treatment that's being provided through the probation is not enough, you need to come by and talk to me, and we'll find a treatment program that works better for you. Again, the idea of this program is to help you succeed. If you need more treatment than what the providers are giving you, then I will find a program that's better suited for you, but you need to talk to me about that. This is a voluntary program. You do have a right to a jury trial. You don't have to enter this program. I do want to go over those trial rights with you, because in the event you enter the program, you do need to be aware when you plead guilty that you give up certain rights. And if I can go over those with you now, it does save us time in court. If you choose to have a trial, you have a right to have 6 jurors hear the evidence. All 6 of them have to agree on a verdict, whether that verdict is guilty or not guilty. You don't have to do anything during the trial. You have an absolute right to remain silent. You have a right to have your attorney present. If for some reason you don't have an attorney and can't afford one, you have a right to have an appointed attorney. Your attorney will be there to cross-examine the witnesses against you, to challenge evidence that's being entered against you, and to argue your case to the jury. You can choose to testify in front of the jury, although you have a right to remain silent. And though you're not required to present any evidence at trial, you do have the right to call your own witnesses, and you have the subpoena power of the court to require witnesses to appear, and you have the right to present your own defenses. The burden, however, is not on you to bring forth evidence. You are presumed innocent. You remain innocent unless and until the state can bring forth evidence to convince all 6 jurors of your guilt beyond a reasonable doubt. So, if you do choose to enter this program, you'll fill out some paperwork with your attorney. Some of that paper includes a plea petition that includes your rights to a trial. I'll go over that paperwork with you, take your plea, and place you on probation for the 2-year period, and set the 60-day further proceedings date. After that, as long as everything is in place at the 60-day further proceedings date, you would only come back one more time after 180 days just to make sure that the treatment is completed. So, you can enter this program on Fridays. I do a live orientation Fridays at 11 o'clock in my courtroom, and you can come in at that time if you have any questions or want to enter Friday morning at 11 o'clock. Or if you're satisfied that you are prepared to enter the program, you can come to my court on Fridays at 1:30 in room 608 of the Multnomah County Courthouse with your attorney and enter the program at that time. Thank you for taking the time to view this video. If you choose to enter the early resolution program, I do look forward to meeting with you. Thank you very much.